Why did the investor keep all of his money in the freezer? He wanted cold, hard cash. One of the ways that people protect money is they're very, very safe about it, either putting in banks or in their mattress. You know, there's a story about a few years ago, I remember hearing this woman who had stored her money in a mattress because she did not believe in the banking system. Apparently she had over $1 million in the mattress. And she didn't tell anyone about it. And one day her daughter decided to surprise her by buying her new bed because the old one was lumpy and was uncomfortable. And she simply took the old bed and threw it away. So being really safe with your money by putting it in the mattress, well, I'm not so sure. Another way that people lose a lot of money is when they're not aware of tax issues related to being a cross-border family. Now, my number one disclaimer of this conversation is that I am not a tax advisor. I do financial planning. I work with people who live in Israel who have U.S. investment accounts. I deal on the investment side. So why am I talking about this? The main reason I'm talking about it is because if you are in the situation that we're going to discuss today, that you are married, you're an American and you're married to a non-U.S. citizen, or if you know someone who is, if that's the case, I'd like you just to take the information we're discussing here, talk to your financial advisor, talk to your tax lawyer, and see what you're doing and what mistakes you might be making. Because this episode of the Goldstein On Gelt Show, if you are what we refer to as a high net worth client, people with in the millions, this could literally save you millions and millions of dollars in estate tax that otherwise you might really have no choice, but, well, you won't be paying it, but your heirs will be taking care of it for you. So I'm going to highlight a few issues. Again, not tax advice. If you are in this situation and you need to talk to someone about it, you just want a starting point. As the financial advisor who helps clients with this, I often say, I'm a good place just to kind of bounce ideas off of, and I'll participate in the meetings with your tax lawyers and with your accountants because I've done this so many times. I know a lot of the questions to ask, and we'll get the answers and the proper documentation from them. So maybe pull out a pen and paper and start jotting down some of the questions that might arise if you, as an American, are married to a non-U.S. person. The first thing to think about is just what do you want to happen in the event of your death? Everyone's going to die one day, and if you predecease your NRA spouse, NRA stands for non-resident alien. So it's a non-resident, meaning you're living outside the United States, perhaps in Israel. That's where I spend most of my time, and most of the clients I work with are in Israel, although we do have people in Europe and around the world. So if your NRA, non-resident alien spouse, is the person to whom you want to bequeath all of your assets, great. That's one. Two, maybe you want to do some charitable giving. Maybe you want to deal with intergenerational transfer, give gift money to your children or leave money to your children. And finally, you might just decide to spend more money. You could spend it today. Nothing wrong with spending money. If it's your money and you earned it and you feel good about it, go ahead, enjoy it. Of course, speak to your financial advisor and make sure you don't overspend. These are the types of goals that people will generally have. I'm sure there are others, and if you have another really interesting one, you can write to me about it at the Contact Us page at goldsteinongelt.com. Okay, what are the challenges? Number one, if you're an American married to an American, much easier. Why? Because let's say you have $50 million and you die. You can leave your whole estate to your American spouse, and there is no estate tax at that transfer point. So that already is why we're not going to discuss that topic today. There are other issues that Americans married to Americans may have, but not for today. Okay, next. An American married to a non-resident alien is going to have to deal with gift taxes, with either gift taxes during his lifetime or is going to have to deal with estate tax afterwards. There are ways and tools we're going to discuss in a minute that you can mitigate some of these consequences that will help to lower the tax burden. So first of all, you can gift to your spouse. If you are an American, you can gift an unlimited amount. As of 2023, an American was allowed to gift to an NRA spouse about $163,000. This is indexed to inflation. It's probably going to be $180-something thousand in 2024, and it moves up every year. So that's actually a pretty substantial sum of money for a lot of families. Therefore, if you're planning in advance and you want to start moving money into your spouse's name, you could start with that amount of money every year. Whatever the annual exclusion is you're allowed to give, you don't even have to report it. You just give that amount of money. Don't go over it, but that's a good way to begin to move money out of the American's estate. The second thing is you could gift, obviously, to your children. When you die, if you have a lot of money, there will be an estate tax. Now, as of 2024, it's still between 12 and $13 million. However, in 2025, it's set to reset to go down to an inflation-linked $5 million, which has been inflation-linked, so it's probably closer to $7 million now, which means that you're allowed to gift that amount of money either during your lifetime or when you die without being subject to U.S. estate tax. One of the issues that a lot of people face is they leave the money to their non-American spouse, which is fine, and then that non-American spouse doesn't understand that he or she is going to be subject to estate tax in America when he or she dies. In fact, we're using big numbers. I've been talking about millions of dollars, but if a non-American, whether inherited or just put the money in America, has over $60,000 in certain types of U.S. assets like stocks or real estate, and that person dies, everything above $60,000 is going to be subject to U.S. estate tax. Now, as a cross-border financial advisor, I help people to set up their portfolios so they don't have this problem. But I've absolutely seen people who end up getting crushed because, $60,000 these days is not so much money. And, if they die and they've got $500,000 or $1 million or $2 million, it could be 40% of that money is going to Uncle Sam that they didn't even understand was going to happen. So it's true when we're throwing around numbers in the millions, but don't forget, if you're a non-American and you have assets in the U.S., speak to someone who specializes in cross-border clients and non-Americans just to make sure that you're set up properly and you won't be subject to this estate tax. And so we spoke about not eliminating necessarily, but possibly eliminating, but lowering estate tax by gifting to your spouse, gifting to your children. Now, one of the terms that gets thrown around a lot is a qualified domestic trust, often just referred to as a QDOT. This is not tax advice, but mention this to your lawyer to see if it's applicable to you. And I'll tell you, the client that I was speaking to this week, who is a very high net worth client and whose spouse is not American, we touched on this issue of a QDOT. And in the end, he decided, I don't really think I'm going to use it, but I just want the possibility that my wife will be able to use it. So they're including that in his will. Basically, the idea is that if an American dies and is subject to estate tax, in theory, he'd have to pay the estate tax now. It would be due right after his death. However, if the money goes into a QDOT, a qualified domestic trust, so then the non-American spouse could actually get income off that. And there's no estate tax when the American dies, and only when the non-American dies, that's when the estate tax would be due. Now, for a lot of people, this is not a great solution, but it's brought up so often, I just wanted to describe to you what it is. And these QDOTs can be structured depending on your family situation, first marriage, second marriage, kids. These are all things you want to bring up with your lawyer. And again, the main idea is you're deferring the estate tax. It doesn't eliminate it, it just defers it. I personally prefer, depending on the size of the account, if you can eliminate the estate tax through gifting and charity during your lifetime or charity at your death, that to me seems like a pretty good model. When you're talking about passing the money to your kids, the first thing I believe is that you should make sure your spouse is taken care of. That's number one. The second thing, once number one is taken care of, is to consider what your kids need or what you want to give to your kids, and then make sure that all of this is done within the framework of watching out for your taxes. So make sure, like we said in the very beginning of this discussion, decide what your goals are. I believe that, in fact, every case that I talk to, people want to make sure their spouse is taken care of, then their kids, and then they want to talk more about taxes. The key considerations here are to make sure you do comprehensive planning. Once you're a cross-border client, your situation is more complicated, and you need to make sure that you're dealing with professionals. That's where you'll get the good guidance to make sure that you don't make a mistake, and make sure that you discuss this with your family. In order to get everyone on board and not to have lawsuits, occasionally, I'll tell you, I see clients who die who didn't plan, and people end up in court. And in fact, we're dealing with a client who died, 4 or 5 years ago or more, and her estate is still in court because she wasn't clear about what she wanted. I think her lawyer should have helped her to be a little more clear. But the bottom line is, if you don't understand your estate plan, if you can't read your will and understand what it says, find a lawyer who can work with you, who can make sure you understand what's going on. That's how you get this stuff done on time, hopefully before you die, because afterwards it could be much, much more tricky. Okay, I hope this was useful. I hope this gave you the introduction that I was trying to give you, that people need to understand when they are married to non-U.S. citizens. Once again, not legal, not tax advice. I deal with this from the investment side. If you have any specific questions related to your investments, and especially as it relates to being married to, when there's an American married to a non-American, feel free to get in touch with me at goldsteinongelt.com. Just click on the Contact Us button. If it's a general question that you want me to discuss on air, I'm happy to do that. If it's specific to your case, I don't usually go into really specific cases on the air. So just leave me your contact details, and if it's something I can help you out with, I'll be sure to be in touch. Thanks so much to Steve Stewart, my chief engineer, to Yosef Goldstein, my producer, to Batsheva Goldstein, who manages the website. And of course, thank you for joining me, Doug Goldstein, here on the Goldstein On Gelt Show, the financial show for people living in Israel. See you next time.